What Craig Murray describes as a schizophrenic approach could take place, where they do actually work to stop them torturing, but they act, let's take the instance of merely being a passive recipient of information that they know may well have been obtained under torture, logically, because they know it's happening. They have no intention of using it in any proceedings to comply with the A and others' judgment, but there may be stuff in there that they feel they're entitled under the bit of Lord Bingham's ruling that you read out, and they won't know in advance. They can't say, well, give us the stuff in April, next April, because we think that has the thing about the bomb in the House of Commons. So isn't it the case that merely being a passive recipient, as long as they do everything else, even though it seems, to use Craig Murray's word, schizophrenic, is a consistent and possibly lawful policy, given the case law that we have from the House of Lords that you have alluded to?
I don't think I can give a better answer than the one that I've given. It might be, depending on the particular facts, depending on the regularity of the flow of information, the context in which the information came. I wonder if maybe turning it around a slightly different way, and I absolutely take your point. I've set out the criteria that need to be met, in my view, on the basis of case law and practice for when complicity arises. And there are essentially three factors. Firstly, there has to be knowledge that torture is or is likely to take place.
Does that include constructive knowledge?
I think it would. I mean, turning a blind eye in the face of overwhelming evidence would constitute, in my view, for the purposes of the Committee Against Torture, knowledge. Secondly, and this I think is the crucial issue, a contribution by way of assistance. And the question then becomes, at what point does the regular receipt of information that is known to have been obtained by torture amount in some way to a contribution? It depends on the factual scenario against which that happens. And the third element is some material effect or substantial effect on the perpetration of the crime. And I think if you go through those three elements, you can begin to see a situation in which the one-off, certainly accidental reliance on information would be in one category, but the systematic reliance in circumstances where you knew, against the background of an ongoing relationship with another state, may well cross the line into complicity.
And actually, it's the contribution by way of assistance that has a substantial effect on the perpetration of the crime. So it's a 2 that has 3, is the wording that you identify from the ICTY judgment. See, I have no wish to particularly defend the government, but just in a kind of legal sense, it's hard to see why passive, I'm going to come on to resistance with gratitude, but passive receipt into an email box which you don't close, even with knowledge that torture is taking place, because the rest of your embassy is saying don't torture, don't torture, don't torture. It's hard to see that in itself is contribution by way of assistance, or that it has a substantial effect on the perpetration of the crime, because the fact that you're receiving it passively isn't the reason that they're doing it, is it?
Well, that would appear to be what Lord Bingham had in mind in that passage that I read out, but what I'm suggesting is that you've got to distinguish between different situations.
Yes.
I think there's a world of difference between the one-off receipt of information that comes into your mailbox and then a relationship which is premised on the regular, systematic, continual reliance against the background of a broader relationship between two sovereign entities. Two very different situations.
And that relationship can be, something that goes to that relationship is the fact that you are thanking them and appearing to approve, at least, of receiving the information, and that you're seeking to maintain an active relationship in intelligence receipt. That is one of the facts of the case that would be different from the merely passive case.
I'm not sure whether it's. I think it's in that direction. It's not so much, a letter of thanks and appreciation for what we've just received. It's the question of when you cross the line into encouraging.
Is there a difference here where it comes through third-party countries? This is the point I put to Mr. Murray. I mean, Pakistan, MI6, MI5, clear allegation of they're in the prison. Here we've got Uzbeks do the torturing, the information goes to the CIA send it to MI6. It effectively, I suppose you could say, almost laundering the information, in that presumably they take out some of the source material and say this is what we found out. Is there a break in the chain there, do you think?
I don't think there would be a break in the chain. I think if you are encouraging, the encouragement can be direct or indirectly. If you are aiding and abetting, it can be done directly or indirectly. If you're essentially sending a signal to a state that it is all right to have a policy of abuse and torture, and we will continue to have a sensible sovereign relationship with you, notwithstanding your practices in that direction, that constitutes a pattern of encouragement. And at some point that pattern of encouragement would, I think, constitute a contribution in some way.
If we just take this Uzbek case, I'm sorry to interrupt. What happened with Mr. Murray was this. You had the MI6 chap going along and saying thank you very much once a year. He stopped that, and he started making representations to the Uzbeks saying stop doing torture. Does that change the position when we've got no other direct line to the Uzbeks other than by Mr. Murray saying don't torture?
Well, not if the government of Uzbekistan is getting signals from elsewhere, which allows the regular flow of information.
From the CIA, but not MI6?
Well, it could be through other channels bypassing Her Majesty's ambassador in Tashkent, or it could be through a third government, or it could be through a private actor. There are lots of ways in which these things happen. I don't think that the chain of causality is the crucial issue. I think the question to ask oneself is, at what point does the act of an individual associated with the British government cross the line into encouraging a particular pattern of practices?
I'm a little confused now, because I thought it was common ground, even with the government, that encouragement, using its normally understood word, would already be something that they don't do, because they say they don't instigate others to do so. And I think I've heard ministers say we don't encourage it. I mean, I don't have the quote to hand, and I also thought that that was a given in your opinion, and you were actually only exploring the meaning of complicity, which I think I understand from a dictionary definition to be somewhat short of encouragement, because if complicity is encouragement, you use the term encouragement in criminal law in this country anyway. So do you accept that as soon as you say this complicity amounts to encouragement, you're making the case? And what I'm trying to explore is where there is something that is not clearly encouragement, but is complicity.
I'm not sure I'd accept the distinction between the words encouragement and complicity. I mean, the term in the Convention that we're stuck with, for better or for worse, is complicity. And so there's been some case law on what on earth complicity means. Different writers, different courts, different bodies call it encouragement, aiding and abetting. I think at the end of the day, it's much of a muchness. The question is, let's put it in a different sense, the issue that's been very much in the news in the past week. More legal memoranda have emerged following President Obama's decision to release information. It's become now very clear that as at July 2002, the Central Intelligence Agency and then several months later the Department of Defense moved to a policy of interrogation techniques which in my view constituted torture. The crucial question, I think for your purposes, and it's been raised by Mr. Murray, is at what point did the British government or those associated with it have knowledge, direct or indirect, of that change of policy? And at the point that such knowledge arises, the failure to engage with the United States and say, hey, this is non, we don't do this sort of stuff, that's not who we are, could be seen as a policy of encouragement and could be seen as bringing individuals into complicity through turning a blind eye. I addressed that a little bit in the issue that I addressed in a lecture that was given a couple of years ago to Justice, when the facts were less clear, but when we could begin to speculate at what point turning a blind eye constitutes complicity. And I think what I'm saying, I hope what I'm saying, I've not made it clear, this is what I'm hoping to say, that when you cross that line, when you encourage another state's actors to engage in acts of torture, you are at risk yourself of being complicit in that torture and caught by Article 4.
Absolutely. I mean,